Noon Club. I am Bob Dickey, the moderator of High Noon Club, and let's get started right away. I see the Honorable Scott Pruitt has just made it into the room and is seated. So please, no one attack our Attorney General. Please do us that favor this afternoon. Every High Noon Club we open with an opening prayer and a pledge of allegiance to the American flag. The American flag's up front. Our opening prayer is going to be the Reverend Dr. J.T. Tagle will be doing our opening prayer this afternoon. Thank you.
Would you all bow your heads with me, please? Abba, Daddy, we humble ourselves in your presence, thanking you that you are God. You have created us. You have created the world we get to enjoy. Some of us are eating, Lord, and we thank you for the food that you have provided. May it strengthen our bodies that we might in turn strengthen your kingdom. Father, we continue to lift you up and thank you for our elected officials. Some we aren't too happy with, some we are. And so, Father, we pray that we thank you that they have the courage to step out and run and put themselves out there and to be elected by the people. Father, it is our prayer that we will have godly men and women who will step up to the plate to be able to be elected, as our country was founded upon those biblical principles. And at one point in American history, you couldn't run for public office without being a Christian. So, Father, we humble ourselves in your presence, asking for your anointing upon our meeting. With our speaker today, our Attorney General, Mr. Scott Pruitt, we ask that you will be with him, you will guide him, you will direct him, that our spirit and your spirit and his spirit will all mingle together, that you will be glorified in everything that's said, done, and thought. And we ask this in Jesus' name. Amen. Amen. Amen.
I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Please be seated. Once again, I'd like to thank the Honorable Scott Pruitt for coming and speaking before High Noon Club, and it's very much our honor. Now, what he's going to do, he's going to give a presentation, talk, lecture, whatever we want to call it. And then after that, you'll have the opportunity to ask him some legal questions that may be on your mind on certain Obamacare issues or federal issues or issues relating to the state of Oklahoma. So kind of get your questions ready. Mr. Attorney General, you've got our microphone up front. And I'd like to just, for the people that do not know, Scott Pruitt was a previous ex-legislator and run for the office of Attorney General and was elected this last election cycle. And Scott, we really appreciate you coming to High Noon Club and discussing what's going on at the Attorney General's office and get ready for a Q&A after. Thanks. The microphone's yours.
I used to be somewhat agile playing baseball, but you know, as I've gotten older, I'm not as agile as I used to be. So if I fall on you, forgive me, okay? It's a pleasure to be here with you. I think y'all have the coolest name of any group that meets. You know, the High Noon Club. I mean, to come to this group and talk. I've been with you before, and it's always a joy to be here. And looking forward to talking to you about the issues that we're involved in right now, because we've got a lot of things that we're affecting. I think leading on that you care about. It's been an interesting few months for me beyond just the legal front. My daughter is a freshman at OU, and so for the Okies and the Cowboys in the room, please forgive me, but she's a Sooner, and she's actually a cheerleader there at Oklahoma University, and so Marlene and I sent her off in August, and we, you know, as a dad, I've been talking to several folks about that process. And it's not been easy. It's been quite challenging, I think, mostly for my wife, but also for me. But you know, she's keeping in touch. You hear these stories about how when the kiddos go off to college and they're there, they don't text, they don't call, they don't write. McKenna's texting quite a bit because she needs money, and so she's staying in touch. But I read this story the other day about a young lady who had been off campus, and I'm sure this is legend and fictional, not true, but she had been off campus. Away from home for about 4 or 5 months, and it was late in the first semester, and she had not texted, she had not called, she had not sent a letter to her mom and dad at all, unlike McKenna. And she sent the letter to her dad late in the semester and says, "Dad, everything is really good here. The dorm did burn down, and I did lose all my personal effects and my textbooks, but I found a place off campus to live with a new roommate, Jim. And Jim's a great guy. He's been in recovery for almost 6 months now. And I know, because I haven't written you and I haven't talked to you, that you didn't know about the wedding. It was happened very quickly, but I know that you're not going to miss the impending birth of your new grandchild. She says sincerely and writes her name. She says, P.S. Dad, none of the things above are true. I did flunk chemistry. I just wanted you to keep things in perspective. I'm not getting those kinds of messages, and I am so thankful. But it has been a time of transition. You know, my youngest is a freshman in high school, and so we've got one at home. I told him when McKenna left the house, I said, I really feel for you, Cade, because all this attention that's been divided between McKenna and Cade is now going to come your way, and so you have no hope here. So Mom has been focusing all of her attention on Cade, and he's weathering the storm there. But anyway, I really am excited to talk to you about what we are doing in the AG's office. And you know, when I ran for office in 2010, one of the things I talked to you about, and I've talked to many across the state, is the importance of federalism. In fact, one of the things that I did upon being elected is establish the first office in the country, an AG, having a federalism unit. We actually set up a federalism unit internal to my office. I put an attorney in charge of that. We've got a couple of attorneys that spend most, if not all, of their time on issues that tracking, executive orders, agency action. The litigation that I'm going to talk to you about today is in that office and in that unit that I set up after having been elected and sworn in. It's really interesting. I've been on some panels with Heritage in D.C., and national media will come to some of these meetings that we have, whether I've testified before Congress about our Affordable Care Act case that I'm going to talk to you about today. But as I've gone to D.C. and talked about these issues, it's really interesting to hear the perspective of the national media. Most of the time, they'll sit in the back of the room and we'll close our presentation, and then they'll ask this question: why are you wasting your time? And why are you wasting the resources of the state of Oklahoma and all the other states that are involved in advancing these types of cases? And I look back at them and I'll say to you what I've said to them. It's my job. It's my job as the Attorney General for the state of Oklahoma, when the federal government is given certain authority and the state is given certain authority under the Constitution and congressional statute, when the federal government usurps that, extends beyond that, who else but an Attorney General will step into the gap to respond?
That's right.
And so these cases that I'm going to talk to you about today really go to the heart of what federalism is. You know, when we talk about federalism, a lot of times, I've been on campus at OU. I've done some other events involved with just attorneys and judges. When I talk about federalism, I've said this to them. Sometimes it's just seen as academic. Sometimes it's just seen as an abstract legal concept. Federalism is real. We know in this room about the checks and balances that exist between the branches of government. Horizontal checks and balances is what I call it. Between judicial and executive and legislative. We know that. We're taught that in 5th grade civics. Federalism is just vertical checks and balances. The founders got together and said, you know what? We know that when you concentrate too much power in a centralized government, liberty suffers. Freedom suffers. And so that's why they were committed religiously to the horizontal checks and balances and also the vertical checks and balances of saying to the federal government, you have authority, you have power in these areas, enumerated, limited, and specific. You know, when I was in law school, in constitutional law class, we spent about this much time talking about those things. We spent very little time, if any, talking about the fact that the federal government is a government of limited, enumerated, and specific power.
That's right.
And so these cases that I'm going to talk to you about either flow from the Constitution and the authority vested in the state, or by statute that Congress has recognized the authority of the state. The first one I want to talk to you about is the Affordable Care Act case. And I know you've been following that. You know that after having been sworn in, within 2 weeks, I filed a lawsuit on your behalf in the Eastern District of Oklahoma against the Affordable Care Act. I did that within 2 weeks. Now, I will tell you, when I filed that case, there were many that wanted Oklahoma simply to join the coalition in Florida. And it was not a question of whether we were going to engage, it was how we were going to engage. And so we spent quite a bit of time as an office evaluating the prospects of whether we should follow in Oklahoma or join Florida. Because Florida was way ahead. You know that they were already on their way to the 8th Circuit. Their case had been litigated at the district court level. My good friend Pam Bondi was calling me saying, please join, just come on and join us. And I couldn't get over something that we did in November of 2010 as a state. In November of 2010, what did we do as a state? We passed an amendment to the Constitution. And the people of Oklahoma said no government, including the state, no government can compel the purchase of health insurance. That's what we did as a people. And so ultimately it boiled down to this for me. Fundamentally, it was better for me to defend the Oklahoma Constitution before an Oklahoma judge as opposed to joining 25 other states in the state of Florida. Now, that decision has borne out to be a pretty important decision, and here's why. When the case came down last year, NFIB versus Sebelius, I was actually there in March when the case was argued. I was there in June when the case was handed down. When the case was handed down, we had the only live case in the country as a state at the district court level. Now, why does that matter? It matters because it allows, when you're in the district court and not at the appellate court, you can amend your lawsuit. So we were able to look at the decision that was handed down and evaluate what was said from spending power across the board, and we could do something else pretty important. We could look at how the law was being implemented by the respective agencies responsible for implementing the Affordable Care Act. And so we started tracking HHS. Part of what we've seen on the contraceptive mandate with Hobby Lobby, that's an implementation issue. That's HHS exceeding its authority and affecting the First Amendment rights of Hobby Lobby just down the street. The state of Oklahoma has filed an amicus in support of Hobby Lobby. We have been in that case with David Green, and God bless David Green. Amen. For someone to stand up and say, I will not die. David is somebody you know. They don't know this nationally, but we know it in the state of Oklahoma. It's not a Johnny-come-lately issue for David. Hobby Lobby exists, and he tells you this, to advance the gospel. And he's been blessed beyond measure, and for him to stand up to Kathy Sebelius and the federal government and say, I'm willing to what? Pay $1.2 million a day for the sake of the life of the unborn is something we ought to celebrate and applaud. Amen. And he is to be commended and prayed for. Amen. But that is an implementation issue with HHS. But there's also another very important issue that our case has now become and focused upon is what the IRS did after the case was handed down in June. They, a month before, passed a rule in May of 2012. And the rule was a pretty important rule because it took the provision in the statute, in the Affordable Care Act, and it said that whether a state sets up a healthcare exchange or not, we're not going to pay attention to that. We're going to make sure the subsidies flow in all 50 states, irrespective of whether healthcare exchanges have been set up by the state or not. Now, to give you some context, there was one decision in the original version of the Affordable Care Act that was reserved to the states, whether to set up a state healthcare exchange. And the federal government knew that they could not commandeer the states, require the states to set up a state healthcare exchange, so they incentivized it. Instead, we're going to encourage the states to set up these healthcare exchanges by dangling these subsidies that flow to individuals under the law. We're going to say that those subsidies will only flow through a state healthcare exchange. Well, they exercise poor judgment. And here's why. 34 states have said no. 34 states have said, we're not going to set up the exchange irrespective of whether the subsidies flow through that exchange or not. So the IRS came in after the fact and said, well, we'll fix that. We'll fix that. We'll pass a rule that says the subsidies go through federal and state exchanges. Now, why is that important? Because if subsidies go to an individual who's employed by a business, if you have just hypothetically, if you have a business of 600 employees, your first 30 employees are exempt under the law. So your total is 570. If one of your employees at that business qualifies for a subsidy and you have not provided the type of health insurance that the feds say that you have to provide, you get taxed on all 569 employees at $2,000 a pop. So for one person receiving a subsidy, you get taxed to the tune of over $1.2 million. So it was a way to fund the structure of the Affordable Care Act. So our lawsuit, we amended it to sue the IRS in August of last year. And the lawsuit is effectively this. There's no exchange in the state of Oklahoma. The policymakers have made a decision. The governor and the legislature said no state health care exchange. So if there's no exchange, there are no subsidies. And if there are no subsidies, there are no employer mandate penalties. That's the lawsuit. Indiana has followed suit. They have now filed a lawsuit. There's a private plaintiff in D.C. that has filed a lawsuit, a business, that has said you can't assess it against us either. The momentum is there. Forbes did an article about a month and a half ago about Oklahoma's case, our case, and said if Oklahoma is successful in its lawsuit, the structure of the Affordable Care Act falls. That's how important the case is. So, you know, I was asked when I appeared before Congress about the case, there were some Democratic congressmen on the panel that they weren't really asking questions. They like to make a statement and then say, don't you think? But as they were commenting about our lawsuit, one of them said, why don't you just get over this? The law it's the settled law of the land. I mean, the Supreme Court acted in June of 2012, that should settle it. And my response to them was, no. All the Supreme Court settled in June of 2012 was whether facially they believed that it was constitutional, the law. Did they have taxing power to do it? That's all they settled. They did not settle whether the HHS is implementing the law consistent with congressional mandate. They did not settle whether the IRS is enacting and implementing the law consistent with the statute. And they're not. And our lawsuit is about holding them accountable. And we hope we had a big victory in July. The feds came in and filed a motion to dismiss, saying that we could not even bring the case. That Oklahoma didn't have standing to bring the case. We won that in July. So now we're proceeding to the merits. I anticipate that we will get something on file sometime probably in the next month or so before the end of the year on a motion for summary judgment. We're going to ask the court to render judgment in our favor based upon the merits and the plain reading of the statute. And if we get a decision in the first quarter, you know, the D.C. court has already indicated they anticipate a ruling by February or March. You could see some cases coming down within 4 or 5 months that go to the heart of the ability of the federal government to implement the law. And so I'm hopeful. I want you to hear, and I really mean this, you know, as much as I detest the law, I think it's terrible for America what the ACA represents. I think it's bad policy. I think it's a bad statute. It needs to be repealed. It is terrible for this country. But I will say this to you. My lawsuit is not motivated on policy grounds. My lawsuit, and our lawsuit, is motivated on one thing: rule of law. We ought to care about that. And we ought to care that when an agency exceeds its authority or something is done unconstitutional, that there's someone to stand in the gap and say, we're going to hold you accountable. That's the motive behind the lawsuit. And hopefully we'll have success as we head into the first quarter of next year. And then it will be a case that will be appealed. If we win, they'll appeal it, and otherwise. But I will say this to you. Be praying, and I mean that sincerely. Be praying that we are provided success at the district court level, that we win. Because if we win, we will get an injunction. And while the case is being appealed, they will not be able to enforce the law in the state of Oklahoma. And that will be a wonderful thing for all of Oklahoma. Two other cases I'll mention to you revolving around the EPA. There are several that we have. I hate to tell you. I'm just going to highlight two. And, you know, just generally there's this attitude that comes out of Washington. They take a statute and they look at the statute and say, you know what, I think it's our job to improve upon the statute. It's not to administer the statute. It's to improve upon it. And the EPA is one of the best at looking at a statute and saying, you know, I know the law says this, but really, they meant this. And so we're going to do this. And in one case that we've been involved in since March of 2011 is extraordinarily important to you as a consumer of electricity. And it's the Regional Haze case.
Right.
And I don't, when I come to these meetings, I hope you forgive me, I don't want to get too in-depth on the legal side. I really don't. I want to be instructive and helpful to you as far as helping you understand what we're doing. So if I get too technical, forgive me. But I think to understand the context, I need to dig down a little bit. The Clean Air Act was passed in the 1970s. And remarkably, in the 1970s, now think about this for a second, in the late 1970s, Congress got together and they said, we're going to pass a part of this statute is going to deal with regional haze, visibility. We're going to set a goal that by the year 2064, now think about it, late 1970s, Congress gets together, says by the year 2064, we're going to reach natural visibility in all these federally classified areas. In the state of Oklahoma, that's the Wichita Mountains. So they got together and said, okay, we're going to do that. That's the goal. You've got to meet the deadline by the year 2064. But because it involves aesthetics and visibility and not health, the states are primary in determining the plan on how to get there by the year 2064. They can actually engage in a cost-benefit analysis. They can actually say, if we put scrubbers on all these coal-fired plants, it's going to cost X, and it's going to reach this kind of improvement in deciviews for visibility by this time period. And we went through that analysis as a state. And that was given to us by statute. The state is primary, responsible, number one, as far as developing that plan on how to meet the goal of 2064. Well, in 2010, we did that as a state. Lisa Jackson, within the first 3 months of my term, came into the state of Oklahoma. She's the former administrator of the EPA. Came into the state of Oklahoma and said, I don't like your plan. And I don't like your plan, and this is me editorializing here, but it's it's spot on right. She came into the state of Oklahoma and said, I don't like your plan because you're keeping fossil fuels in the fuel diversity mix. Coal. You're still burning coal. And we don't like coal. And so we're gonna force a federal plan on the state of Oklahoma. In the federal plan, and I'm going to say this slowly because sometimes I get going too fast. The federal plan was a $2 to $2.5 billion plan that OG&E and PSO they were going to have to implement over a 3-year period. $2.5 billion of capital infrastructure to comply with Lisa Jackson's objective to eliminate coal from the fuel mix. It was going to cause your utility rates, my utility rates, to go up 20% within 3 years and annually thereafter. Hugely important to the people of the state of Oklahoma. Hugely important to economic development. Because businesses for a long time in Oklahoma, one of the greatest benefits we've offered them is competitive energy for them to grow their manufacturing base and their business. So she came in, rejected our plan, we sued her. A few months, I sent her a letter first, it wasn't persuasive, and then we sued her. Or she wasn't persuaded, I should say. It was persuasive. She wasn't persuaded. But in any event, we sued her saying that the state has ultimate authority under the statute. I argued that case in Denver in March of this year. We lost that 2-1. It was a 3-judge panel. We lost that case. It's a case of first impression. North Dakota, Colorado, a lot of states to our west are very concerned about the case. I'm not here to announce anything right now because we're still evaluating. We literally got the final decision from the 10th Circuit yesterday. So we're looking at all that right now. But let me say this to you, probably very soon, I'm going to announce that we're going to take that to the Supreme Court. That we're going to stand up for what we did and make sure that the feds are coming to court. Now, let me say this to you. I was asked by the Chief Judge of the 10th Circuit when I was presenting the case. The Chief Judge looked at me and said, do you believe, Attorney General, that the EPA has no role? And I said, no, that's not my position. My position is not that the EPA doesn't have a role. My position is that it's secondary to the state of Oklahoma. And if Oklahoma does its job under the statute, which we did, what I didn't tell you is that our plan that we submitted in 2010 beat the deadline by 15 years. So it wasn't a question about whether Oklahoma had acted responsibly. It wasn't a question about whether we had evaluated the cost and looked at the benefit. It wasn't that we never met the natural visibility standard by the year 2064. It's just they didn't like it. It's just that they didn't like what we did. And I told the Chief Judge in Denver, I said, I'm an old baseball guy. And under the statute, we're the umpire. And we get to call balls and strikes in the state. Now, if there's a pitch on the outside half that maybe looks like a ball, maybe looks like a strike, we call it a strike, that's our judgment. We're the umpire. Now, if we call a pitch that's thrown on the backstop a strike, then that's unreasonable, and the feds can step in and say that you didn't rightly do your job under the statute. But that's not what happened here. And so that case, we're going to press, likely, to the U.S. Supreme Court to hold the EPA accountable, to make sure that states like Oklahoma and other states that are watching this get to do their job that Congress said that we should and shall do. And that's very important to your utility rates. It's very important to the future of federalism as it relates to the Clean Air Act. Now, one other case I'll mention to you on the EPA that is as egregious, and when I share it with you, you know, I don't know if it'll shock you, it shocked me. But there's a little thing that it looks like the EPA is engaged in, a little procedure that they're engaged in that we've termed sue and settle, where there are certain environmental groups, Wild Earth Guardians, Sierra Club, various environmental groups across the country. They will bring a lawsuit against the EPA and the Department of Justice under clean water, clean air, some environmental law. And it's endangered species is another example. But they'll come in and sue the EPA and they'll say, you know what, you need to do this. You haven't done it, you need to do this. And the same day that the lawsuit is initiated by that environmental group, guess what the EPA does? Raises their hand, raises the white flag and says, oh, you got us. Wink, wink. And then that day, they enter into something called a consent decree. And in that consent decree, they bind themselves, the EPA binds themselves to obligations that don't exist in the statute. As an example, maybe something's discretionary under the Clean Air Act or Clean Water Act. And in the consent decree, they will make it mandatory. And they'll bind themselves to say it's no longer discretionary, it's mandatory. Or maybe there's a timeline that states are trying to implement certain plans, like our Regional Haze case, and the EPA, in a case out west, will come in and say, we're going to accelerate that plan through this consent decree, affecting states all over the country who are not even in the lawsuit. One lawsuit that was brought by the Wild Earth Guardians, they sued the EPA, it affected our timeline in the state of Oklahoma. North Dakota found out about it, tried to intervene in the case. Justice and the EPA argued against it and said, North Dakota, you can't get in the case, and it affected North Dakota's compliance under the Regional Haze statute. That sounds like a due process concern to me. So what we did last year, very reasonable, I think, we sent a letter. We sent a lot of letters from the AG's office. And we sent a letter to the EPA. And we said to them, under the Open Records Act, under FOIA, we want you to provide all emails, all letters, all communications with these environmental groups around these cases. We identified 40 to 50 cases. They came back, I know it's going to shock you, and said, no, that's too broad a request. Now, I don't know what's too broad about that. We identified the cases, we identified the groups, we identified the type of records. They said that was too broad. We're good folks in Oklahoma, as you know, so what we did is we amended our letter. And I sent a follow-up to the EPA director, and I said, well, okay, here's what we'll do. Just give us all cases around the Regional Haze statute. So these cases, Regional Haze, these types of records with these environmental groups. Again, shocking. I know you're going to get me shocked. They said no. Okay? So in August of this year, 12 states, Oklahoma is the lead state. We sued the EPA under FOIA. And we said to Lisa Jackson, now Gina McCarthy, Madam Director, we're entitled to the documents. Give us the documents. We're not going to presume that you collaborated. We're not going to presume that you colluded with the other side, but we're suspicious. We just want to see the documents to see whether there's been some kind of unholy alliance and why you didn't defend what you were doing to comply with these statutes and you agreed to settlements that affected our states around these statutes. So that lawsuit was filed in August of this year. We are pressing that as we speak, and we hope to get those documents produced so that we can determine whether there was collaboration with these environmental groups in advance of litigation. Now, please, here's the caveat. I'm not saying to you that consent decrees are a bad thing. Consent decrees are a proper mechanism to settle lawsuits at times. But when you take a consent decree and put in it items that change law, when you come in and say it's discretionary, it's not mandatory as indicated, or the statute says 3 years, we're going to take it down to 1, that's an abuse of consent decrees because you're regulating through litigation. And that's an abuse of the court system. The EPA should not be achieving policy objectives through litigation. They ought to be defending the statute and the rules that they've adopted against challenge. That's their job. And they have used that process potentially in abusive fashion, and we're trying to do something about it. And again, that's 12 states that have joined together to hold the EPA accountable. So those are just two areas. There are many others. I will say to you, of all the issues involved with the EPA, there are two that are the most concerning to me right now. One is the greenhouse gas rule. They just adopted a greenhouse gas rule that changed what coal-fired plants and natural gas plants are allowed to produce. And they have an obligation, the EPA does, that when they change that, they have to show that it's achievable through technology. It has to be demonstrated. You can't just come out and say, well, we think it's 1,000 parts per million or whatever, and it's never been demonstrated. We don't know if the technology's there, but you're going to do it anyway. They can't do that under the statute. They have to show that it's achievable and has been demonstrated. Well, the rule that they just adopted, again, shockingly, they didn't do that. And so we are looking at a challenge under the greenhouse gas rule. We're not there yet because they're still in rulemaking. Okay? But that may come, it may come sometime soon. One other area that is very concerning to me is their assertion that they have jurisdiction over hydraulic fracturing. You know, in Ohio, in Pennsylvania, in New York, and other places on the East Coast, they think hydraulic fracturing is actually a new thing. And it's not. It's been around about 40 to 50 years. And what is new is the technological advancement that allows us to go down 2 miles and go left or right 2 miles and extract from shale natural gas and oil that we could never extract before. So there are new applications with it, but hydraulic fracturing has been going on for a lot of years, for decades. And even more than that, states have been regulating it for decades. We have a robust regulatory regime at the state level through the Corporation Commission with respect to hydraulic fracturing. The EPA, and again, I want to say this slowly, Congress has said the EPA has no jurisdiction over hydraulic fracturing, save one thing. If a company is using diesel in its injection fluid, then the EPA has jurisdiction under the Clean Water Act. If a company doesn't use diesel in its injection fluid, there is no jurisdiction. Despite that, the EPA is in the midst of a 2-year study to come in and displace states and the regulatory regime and to duplicate or, again, to displace and take over the regulation of hydraulic fracturing. Now, what does that mean? It means slower permits. It means slower time for us to access natural gas and oil, and that's exactly what they want because they don't want us burning what? Fossil fuels. The EPA has an anti-fossil fuel agenda. It's not anti-coal, it's not anti-natural gas, it's anti-fossil fuels, period. And just so that you know, you probably know this, but just for a little piece of statistical information, coal serves 50% baseload energy in this country. That's right. So all the energy that we produce to keep our economy going and for you to turn on lights today, without any economic growth, 50% of it is provided by coal. If coal is taken off the grid because of what the EPA is doing, saying that coal is bad and we're going to take it off the grid through all these regulations and whatnot, I got a question for you. What are you going to replace 50% baseload energy with? And for those environmentalists to think that they're going to replace it with renewables, that is fanciful. Renewables will not replace coal as it relates to baseload energy, ever.
That's right.
Ever.
That's right.
And we have to take a stand against a mentality out of Washington that says that we can't burn coal, we can't burn natural gas, we can't burn fossil fuels because our economy will come to an absolute standstill if that's the case. We will go backwards by a lot, and that's exactly what's happening today. And I don't want to get to preaching, but I will say this to you. I'll say this to you. We need to be unapologetic as a nation and as a people. We do it better than anybody in the world. We set the curve on how you produce and explore energy versus any other nation in the world. And I'll tell you this, if this administration or these folks in Washington want to show leadership in the areas around these environmental concerns, they need to call China. They need to go to India. I was in China about 12 years. I was there in the late 1990s, 2000 time frame. And when I got back to the hotel at nighttime, I could feel it in my lungs. But yet America, we're going to take the brunt. It just doesn't make any sense to me from the why hasn't the Keystone pipeline been built? And I'll tell you why it hasn't been built. Anti-fossil fuel agenda by the EPA. And so what we're dealing with on a day in and day out basis in my office is responding to the rulemaking, the actions that the EPA is taking that is inconsistent with the statute, and they do it because they feel like they can get away with it. And I'm so thankful that I've got a group of colleagues, a group of friends across the country, from South Carolina to Florida to Texas. I kid Greg Abbott in Texas quite a bit. He's going to make a great governor in Texas, by the way. But Greg Abbott, I told him a few months ago, you've got 13 or 14 lawsuits against the EPA. I'm trying to catch up. I've only got 3. I'm trying to catch up. So we're fighting the battle. You know, the AGs across this country are the front line, the last line of defense to give true meaning, life, and meaning to the Constitution and the role of the states in this thing called federalism. You know, Teddy Roosevelt one time said, and I think this is a great statement, in any given situation, the best thing you can do is the right thing. The next best thing you can do is the wrong thing. The worst thing you can do is nothing. And I will tell you, as long as I'm your Attorney General, around these issues, we sit in our office, my office, day in and day out saying, what is our responsibility? How do we act? How do we preserve? How do we hold these folks accountable? And it's an honor to serve you as your Attorney General doing that. So thank you very much. Appreciate it.
Good job. Okay. Let's get into some Q&A. Let me kind of make one additional statement regarding the pipeline. Okay? Most people do not realize this. I'm going to add a little caveat to what you just said, Scott. Most people do not understand another reason that pipeline, they don't want that thing built across the United States, is because who owns the majority interest in the Burlington Northern Railroad, and also the tank car company called Union Tank Car Company is, guess who? Warren Buffett. So all that fuel is being hauled by the railroad. That's the other part of that. That's the economic factor involved in that. If he would sell off all that Burlington Northern stock and that Union Tank Car Company, I guarantee you the next day that bill will be signed in the legislature.
To interject something there that I didn't share with you, the president relies upon, and this decision, it's remarkable to me in America that one person is standing the line of the pipeline. I mean, just think about it. I mean, one person literally is keeping, we've got the Southern Portion Bill, Canada wants to export it, it's hugely important to all of North America, and one person is standing in the way. He's relying upon an executive order from 1968. Now, you've read the Constitution. The Constitution gives to Congress the regulation of foreign commerce.
Right.
If the Keystone Pipeline is anything, it's foreign commerce. And they try to come in and say it's some kind of national security issue. Well, that's ridiculous. I mean, and he's relying upon a 1968 order. You know, Congress needs to step up to play, both in the Senate and the House, and say, you know what, it's our job to regulate foreign commerce. We're going to authorize the pipeline, and we're going to make you do it, because the president doesn't have that responsibility under the Constitution.
That's right.
So just a sidebar comment there. Bob?
Okay, now it's my turn. Okay, Q&A, get to raise your hands or whatever. Okay, yep, so let me start over here and then I'll work towards the back. Now I'm going to ask you a little favor here, Pioneers, today. Let me work the back and then do the front, so if you've got some front questions, we'll kind of get to them next.
Hi Scott, my name is Woody, and I want to thank you for coming today. You've been very informative. I want to thank you first for not mentioning states' rights, because we don't have states' rights, we have sovereign powers, and that's where your federalism comes into play. Thank you for that. A lot of people don't understand that. The question I want to ask has to do with the Obamacare. There's a lawsuit, from what I understand, in the state of California against the Obamacare Act, stating that it started in the Senate, and since it's basically a tax or an appropriation of money, and all that stuff is supposed to originate in the House of Representatives. Are you aware of that case? And is Oklahoma going to do anything about it?
Well, we've heard, you know, there was quite a bit of analysis post-script the decision last June around those types of things. I mean, Leonard Leo is a good friend of mine. He has the Federalist Society. There's a group of attorneys that we've worked with and collaborated with on multiple issues around federalism, and that is an area that's been looked at. I will tell you our assessment has been that it probably is one of the weaker arguments that can be made because the legislative history of the bill, it did start in the House at one point, then went to the Senate, and then it was a conference committee report that came out, and it just isn't clear that the CCR, the conference committee report, is not, an extension of what the House did originally. So it's not to mean they shouldn't litigate it. I'm glad to see that case out there. It has been talked about. I think the bigger issues right now are on implementation. I think the better issues are on implementation because they did such a poor job drafting the statute. It was such a piecemeal, 2,700 page statute. And because of that, they've had problems. We've seen that with the website, but that's just a small matter compared to how inconsistent the law is itself. So I think the implementation, whether it's HHS, IRS, or otherwise, those have the best opportunity to affect the structure of the law long term.
Question. Sir, I have a question for you. My name is Leroy Green. What are we going to do about all of our homeless here?
I'm sorry?
What are we going to do about all of our homeless here? Seriously.
Well, from a legal perspective, which is my sweet spot, that's where I'm playing, today. I think that the policymakers in the room, I think they would tell you that they contemplate and consider those issues on each session. I think predominantly, when you look at the homeless and those that are in need of food or shelter, historically our country has been a very compassionate and giving country, and that's gone through the charitable organizations and the churches. Amen. And I think that what has been lost to a certain degree is government asserts itself and seizes the traditional role of nonprofits and churches. What ends up happening is it sucks the very life out of those entities that have done that historically, and it almost gives them license to withdraw. And in some respects, churches have done that. Now, that's not all churches. I think there are certain denominations, certain churches that are very purposeful about trying to minister to those in need. And I just wish that policymakers would do more to empower those types of groups and to encourage that, as opposed to try to seize that from them. When I was in the legislature, we actually passed a bill, or I tried to pass a bill, that provided immunity to physicians who were going to medical clinics to help in the state of Oklahoma, because they could go to India and provide dental services or assistance to folks and not have any kind of impact on their medical malpractice and liability, and they couldn't do it in their backyard. And that was the days. I was in the Senate when it was before we made it to the promised land that the representative here is experiencing. I was in the Senate. I was in the Senate when it was 33-15, Democrat to Republican. So when I introduced that bill, as you might imagine, it was not received well by Stratton Taylor and Gene Stipe. But it's my understanding that we're making progress in those areas now. That's one small thing that policymakers can do. But I think beyond that, incentivizing or trying not to assert government to take away the mission and purpose of churches. I don't mean to go on. It's a tough question because there's a lot of things we can talk about. But I will say this to you. Welfare reform in 1996, we had more people on welfare in 1995 than we had in 1965 after having spent $7.1 trillion from 1965 to 1995. It was an abject failure. And thankfully, Congress took the responsibility in 1996 and said, you know what? We're going to set a deadline when you have to get off. If you're able-bodied, if you're working, you've got 40 years, and you saw people, literally, there was a revolution that was occurring in a positive way as far as people finding work and the rest. And ministry stepping up to the plate to provide help and assistance. That was the charitable choice provision, faith in action, all that kind of stuff. So there's a lot of things that can be done. Unfortunately, we have a mentality in Washington right now. It's paternalistic. It's that they know best. And if we would just get on board, things would be okay. Well, that's not history. And so that's why we have a problem.
Next question.
My name is Jim.
Hello, Jim.
Perhaps a year or so ago, shortly after the Supreme Court had made its ruling about the Affordable Care Act, I believe you were participating in a panel down at OU that I was there and we discussed that in some detail. My question is, would you refresh my memory now? You were saying that under some circumstances, it was appropriate, or the federal government could establish a federal medical system, but under the current attitude that the legislation had been developed, that's what you were considering as being totally improper. Could you refresh my memory?
Well, the appearance on campus at OU actually predated the argument. We went down there and debated with a couple of constitutional law professors, and that was quite fun. But the statement, I don't know, I'll just give you the statement today. It's clear that Congress, under its taxing power, could do that which they tried to do with the ACA. They chose not to. I mean, Social Security, okay, in Medicare, is Congress using its taxing power to achieve the kind of change that we saw with Medicare and Social Security. But when Congress passed the ACA, they knew they could not pass it as a tax. They knew that if they were honest with the American people and said, we're using our taxing power and we're going to do exactly what we did with Medicare and exactly what we did with Social Security to pass this law, that they couldn't pass it. And so they did something different. They said, we'll use our Commerce Clause power. And that's what we were debating on campus at OU. You know what's interesting about the perspective by the so-called intellectuals in the law schools is that when we went down there to debate them, if you put 10 constitutional law professors on a panel prior to the decision in June of 2012 and asked them, does Congress have the authority under the Commerce Clause to do that which they did, pass the individual mandate? If it weren't 10 out of 10, it'd be pretty doggone close. Would say absolutely. They view the Commerce Clause as plenary. They believe that the Commerce Clause gives Congress absolute license to do whatever they want to. I will say to you, I hate the decision that Chief Justice Roberts rendered. But I will say, I want you to know this. We did get constraints for the first time since the 1930s on the Commerce Clause. Chief Justice Roberts recognized, and it's a holding of the court, Congress cannot use the Commerce Clause in a plenary fashion. They cannot. It cannot be used to mandate the purchase of good or service. That was a good thing. They also obviously took the very positive step of saying that under the spending power, you know, before our lawsuit, the representative will tell you, they didn't have a choice on Medicaid expansion. Under the original law, under the Affordable Care Act, every state in the country had to expand Medicaid pursuant to the law's mandate. We sued, the collection of states sued on that and said that violated the spending power, and by a 7-2 vote, we won. The very decision that Governor Fallon and the legislature has engaged in, not to expand Medicaid, that decision didn't even exist prior to our lawsuit. So there were things that came out of the lawsuit that were very helpful to the states to recognize sovereignty and authority. Unfortunately, Justice Kennedy said it best, and I was there when he said it. When they rendered the decision, Justice Kennedy, sitting right next to his friend, and I believe he is his friend, Chief Justice Roberts said, in the name of judicial modesty, the court is saving a statute that Congress did not write. And that's exactly what the court did. Congress did not write the statute that Chief Justice Roberts upheld because they did not use taxing power to pass the law.
For clarification purposes, are you saying that the decision from the Supreme Court upheld the taxing aspect?
Yes.
But not the Commerce Clause?
That's exactly right.
And the Commerce Clause is to be limited rather than expanded?
It has been restricted as a result of the lawsuit. And the court recognized only that Congress could use taxing power to pass the law. They chose not to, but the court said, we're going to fill in the blank and say that they could have, and therefore uphold the law.
And that's why the expansion of Medicaid was not required.
That relates to the spending power. But see, under the law, originally, Congress said this to the state of Oklahoma: you either expand Medicaid or else. If you don't expand Medicaid, we're going to jerk all your Medicaid funding away. Literally. And that was coercion, that was intimidation. The court said you can't do that. The representative here, the governor, other members of the legislature, they cannot be coerced or intimidated under the spending power to do that which you're saying that they have to do. So that was spending power, not taxing power.
Question.
David,
Hello, David.
will you comment on the excessive raises recently given to the head of tourism, banking, and others, how the process works, and can the governor veto the raises along with the increased spending of over $800 million by the Republican-controlled House, Senate, and governorship, and how bad it is for Oklahoma and how bad it looks for us Republicans?
David, really, I mean, from my perspective, it's not something, I know very little about it. There was a study that was done, I think it was, the representative here probably knows more about it than I do. I think there was a study done by a group that published salary ranges, and as a result, you had certain boards and commissions take that study and make decisions about salary and benefits. And that's all I know. And I think in response to your question legally, the question would be whether a board or commission has that authority to do that. And that's not been brought to the surface. I would trust that they do. That's just not something that's been brought to the surface. But boards and commissions that oversee the hiring of an executive director, like the Board of Tourism, they have the responsibility to vote on that. I mean, the Lieutenant Governor, as you know, voted against it. So those bodies govern that. So quite likely it was not illegal or unlawful. It may have been bad judgment, poor judgment, but that's not something I'm involved in. You know, it's not something that I track day to day.
Question. My name is Ron, Attorney General. I
Ron.
want to ask you, how you doing?
Good, sir.
Is there any way legally that we can protect ourselves against Obamacare?
Well, I think as a business, there are certain things that you can do. And again, I'm not trying to provide legal counsel here because that's not my role to you. So let me provide that caveat and disclaimer to you. But as a business, as an attorney advising them, you can look at things and you see it going on. The number of hours worked, there are certain exemptions that are in the law. That's why you see these retailers. The businesses that are hit the most with respect to the Affordable Care Act are retailers, fast food, because the restaurants, because they get paid a very low hourly rate, and they make most of their money, like with waitresses and the rest, on what? On tips. And so what ends up happening when you're a company like that, you have a very low hourly rate, the benefits that are being provided to those employees largely are not what they are at Devon. Okay? And so if you're a McDonald's franchisee and you have 30 different locations and you've got 200 employees, and there's a Sonic franchisee across the street that only has 10 employees and they don't own multiple units, they don't have to comply with the law, but you do. You know, that's how inequitable the law is. So that's the reason you see retailers, fast food restaurants, and others taking the step of saying, well, these are 30-hour employees. You know, we're cutting back to 30 hours or whatever. As an individual, I will tell you, this administration, though they like to talk about being there for the little guy, I don't like that terminology myself, but as they say that, they've done everything they can to hurt the little guy. That's right. Let me give you one example. Under the law, there was a cap on out-of-pocket expenditures. It was in the statute. So everyone in this room, everyone, me, you, everybody in this room, the law said that you were not required to pay out over a certain amount of money. They capped it for any medical procedure that you had. So if you had a $50,000 heart surgery and the cap, I don't remember what the cap was, let's just say for the sake of discussion it was $5,000. It probably wasn't, but let's say it was. You would not be required to pay more than $5,000 out of pocket if your insurance company did not cover all of the $50,000 service. Well, guess what the president did? The president got some pressure from insurance companies, and the president came in and said, well, I'm just going to remove the cap. And took the cap and said, I'm not going to enforce it. Now, I've got a question for you, and it's a question I asked in Washington, D.C. at the Heritage Foundation. If I said to you that we were in the midst of a constitutional crisis, would you agree with me or not? Yeah. You know what? They said the same thing in Washington. But, and that's surprising because I was actually talking to attorneys and judges and other folks there in Washington, and I asked that question. And you know, Article 2, Section 3 of the U.S. Constitution requires the president to do something, and it's called faithful execution of the laws. The president is charged to faithfully execute the laws. What does that mean? That means that when Congress passes a statute and says that there's a cap on out-of-pocket expenditures, the president can't unilaterally say, well, I'm not going to do that. The employer mandate penalty was supposed to go into effect December 31st of this year. I don't like the employer mandate penalty. We're trying to get it removed, as you know. I've got a lawsuit about it in Muskogee. I hate it. But the president doesn't have the power and authority to simply stand up and say, I'm not going to enforce it. I'm going to delay it for a year. That's unconstitutional. This president has acted in unlawful ways multiple times during his presidency. Congress needs to do something about that.
We've only got about 10, 15 minutes, we know that, okay? Let's kind of go a little different direction. I've got a couple different directions, and I'll get to the front there for questions. We, here in Oklahoma, it's really easy to attack the federal system because it's those guys over there, those bad guys over there, and which, according to Bob Daney, I mean, the EPA, gone, just gone. Department of Labor, gone. I mean, those kind of, Department of Education, gone. Now, that's just me. However, in Oklahoma, is there any agencies here in the state of Oklahoma that ought to be gone, according to you? I mean, are we doing everything so perfect? And here's kind of, I'm going to direct my question maybe a little bit differently. Let me kind of style a little bit differently, like I'm going to do a deposition type question. And I don't mean it that way because I don't want it to be political, but these deals are always political, okay? Is there any time that you've actually represented the people of Oklahoma? I mean, really the people, rather than an agency or something like that, or say like, let's talk about this sports agency deal that went on here last week, and I can't even get the right name of that thing, Oklahoma Sport Athletic Association or whatever, that a lot of people here think is just wrong or something like that. Is there any certain case that you've actually represented the people of Oklahoma against one of these agencies?
Well, yes. I mean, the mortgage settlement that we engaged in was on behalf of consumers. Only state in the country. Very proud of this. We didn't join the other 49 states who I think abused their authority under the national settlement. And I can get into that if you want to today, but for the sake of discussion, we went out and we had individuals in Oklahoma that experienced harm with respect to dual track and robo-signing. And under the national settlement, it was a class action mentality. Those individuals in all 49 states got a measly $1,400 check for losing their homes. In the state of Oklahoma, we went out on behalf of Oklahoma citizens and held Bank of America, Wells Fargo, and others accountable for their abusive practices. And our relief has been 10 times, on average, more than what they got on the national settlement. So yes, we have been out there in the consumer context, clearly. And under the statute, I have something called patriot power, in the sense that if there is a issue that the people are affected, we can bring, depending on the statute, on behalf of folks, individuals in the state. I think the Affordable Care Act case that we're bringing is as much about the people of Oklahoma as it is the state of Oklahoma. So I think it's both of those things. I don't necessarily differentiate that way, Bob. May I say this to you, and please hear my heart on this. The EPA, we fight them tooth and nail. Okay, you know that I've shared those things with you. There are issues with respect to clean water and air that cross state line.
That's right.
There is a role, and I think it's important for conservatives, for us to recognize that though I don't like the EPA, though I don't like the authority that they're exercising, though I think they are picking winners and losers, try to elevate renewables at the expense of fossil fuel, which I think is wrong as far as their authority is concerned, I think it's not good for us to say that the EPA doesn't have any role, because that is not true. We have air issues, cross-state issues that do affect. I mean, just think about it. You have a power plant in Arkansas that's burning coal, whatever, irresponsibly or inconsistent with the statute, and it comes over to Oklahoma and affects us. So there is a role for the EPA. It's just that they assert themselves in ways that are above that role. And that's where we see, now there are certain agencies at the federal level that I think have no role. Department of Education is one. I mean, I don't think that the federal government should have any say with respect to the education the state of Oklahoma. But they do, because we have yielded as a state with respect to special ed. We have said that we want special ed dollars, and we get about 40 cents on the dollar, if that. Okay? So I think it's more global as far as there is a proper role for the federal government. We need to recognize that proper role and then make sure that they stay within their lane just like we stay within our lane.
Right.
Just an editorial comment.
Well, okay, good. I think that's a good answer, a very good answer. Appreciate
Well, thank you.
Because that's a tough question to actually answer.
Well, you don't ask me tough questions all the time.
Let me ask you this question, sovereignty issue.
Yes.
Sovereignty. Prince versus United States, which would be Stephen Mack in Arizona, sheriff from Arizona. They took the federal government to task on the idea of criminal agents coming into a state sovereignty issue and seizing property. I don't know if you're familiar with that case at all. Okay. If I was a county sheriff in the state of Oklahoma, let's just say that would I have the right to tell you, this is a very debatable question I'm asking. Would I have the right as a county sheriff to tell the federal agents, no, you can't come into my county, seize property?
I think that with our drug laws at the federal level, they have been used as license to come in and usurp the traditional role of local law enforcement. And we do see, I mean, I'll tell you a concern that I have as an extension of that is that you also have law enforcement, and we work very closely with them, and they are champions on behalf of, they keep us safe while we're sleeping, okay? And I praise God that they're there. They, in certain parts of the country, however, are using what I would term militaristic type of actions, and that's a concern. I mean, domestically, we have private property rights, we have search and seizure Fourth Amendment rights that need to be acknowledged and recognized. And when you go off to war, you don't have that. When you come back home, you do. And so I think at times in application, we have certain federal agencies as an example, DEA and others. There are stories of them going and knocking on a door, getting a tip about some kind of drug issue in some home, and literally engaging in what you and I would call a militaristic kind of endeavor on that home, clearly abusing private property rights. So those are all things that we've got to be mindful of, you know, as we look at these areas. And I do think there's been some usurping of the role traditionally of local law enforcement.
But if I was a sheriff, what would you tell me to do? I mean, what would your recommendation be that I'm supposed to tell these federal agents, no, you're not coming in here?
I'm offering all legal advice today, all right? I'll tell you.
Well, it's really not really so much that because that's what Prince versus United States determined that. That was a Supreme Court decision that actually said that federal agents do not have that right. Now again, I'm kind of sucker punching, and that's not my intent at all with that. But it does give that right, and that leaves that huge question that's still coming with a lot of these different states and their sovereign rights, and as a county sheriff.
And I think you just look at what the Constitution says your jurisdiction is and assert yourself. And that's what you do.
Okay, thanks.
My name is Joe Miner. Appreciate you to be here today, Attorney General. I am also a local attorney. When you were running for office, Jim Priest was your opponent. I remember. Yes. I've had quite a few battles myself with Jim in the courtroom, lost some, won some. When you were running, I did not know that much about you, unfortunately. I knew a lot about Jim just because of my relationship with him. But I remember you saying that you were going to set up the Department of Federalism, that you were going to take the federal government to task. You got my vote when I read that Jim said the federal government is not the enemy. People forget they do many good things as well as things that frustrate us. What we need is a measured response, and hauling off and suing them every time they do something that frustrates us is not a measured response. Attorney General, I'm sure glad I voted for you. One quick question. I was very disappointed at the Supreme Court's ruling in the Obamacare decision. I very much supported the dissenting opinion. Friends that I have talked to have lost faith in our because of this. What response do you give?
Listen, I'm a person of faith. There are many people in this room that are people of faith. And I will say this to you. We need to offer hope. It really is, you know, I think what causes people to be disenchanted and discouraged is they don't really think they can do anything about the problems that they see, and that's just simply not true. It's just simply not true. I mean, people gathered together, marshaled together in elections all over this country can send a message to Washington that says that we are the owners. We're not the serfs. We don't work for Washington, D.C. Washington is not intended to be as consequential as it is in our lives, and that needs to change. And I don't mean that to be a trite answer. We can actually do something about it. The 2010 election was really that. Don't be discouraged. I want to say to you, from the judicial, and the court gets a lot of criticism. The Ninth Circuit gets a lot of criticism, and it should. I've had some issues with our own Oklahoma Supreme Court on some pro-life cases. One that just happened this week, that I think that they are acting not in accordance with the law. But let me say this to you. I would submit to you, in some respects, that the judicial branch is the last surviving branch of the Constitution. I mean, think about it. The legislative branch in Washington, D.C. is entirely dysfunctional. They haven't passed a budget in over 5 years. It is discouraging to me to see people there that represent America, that are there to solve problems and do their job under the Constitution, engaging in the kind of conduct that they engage in. This president standing at a podium in Washington, D.C. with the kind of partisan rancor that you hear from this president is very disappointing. And so we have got to elect adults. We've got to elect individuals that understand their role, but have a commitment to be people of civility. You know, I live in an adversarial world. I mean, we're engaged in litigation all the time, just as you are. That adversarial posture does not give me license. It does not give me permission to hate the person across the table. It doesn't give me permission to act in a caustic way. It gives me, I have a responsibility as an individual to love that person and to lead, but respect them though they may disagree with me. And we have lost that entirely in this country. The art of persuasion, the art of coming together and making, the U.S. Senate should be a place where the debate that we're having today ought to occur in a meaningful fashion, as opposed to just power and majority and numbers. So we have got to gather control of that again, and let people that understand that, and we can do that. And I don't like the decision. I've said that about Chief Justice Roberts. But you know what I saw when I was up there in March of 2012? I saw 9 justices asking tough questions of advocates. Advocates responding to those questions to the best of their ability. It was a beautiful thing to watch. And then a decision was made. When's the last time that happened in Washington? So the process, though it produced a result I don't like, it still was a process that worked. And we have to respect that, and we have to restore the integrity of the legislative branch. The executive branch doesn't need to be dictatorial. It needs to faithfully execute the laws as passed by Congress. And Congress needs to actually pass laws, like budgets, and do something about 17. I heard something the other day. Melissa and I talked about this several times. I was on a panel at Devon on energy, talking about our lawsuits. And one of the gentlemen on the panel was a policy guy from Alabama. And he said, you know, if we just authorized and granted permits to drill for natural gas and oil on public lands, if we just allowed that to happen, it would produce $19 trillion in royalties to the U.S. government. They didn't put the time frame, but whatever it is, 10 years, 15 years, whatever it is. How about a law in D.C. that says we're going to drill and we're going to take all the royalties and assess it against the debt? Now, that's an 80% issue in this country. Most people, even in New York, would say, God bless that. Go drill and get the national debt taken care of. That's the kind of thought process we need to have on ideas. But I would just encourage you with this. Contend for what you believe. Stand for what's right and true. But do so with civility, do so with love, and know that we're there to persuade folks, and there is hope. And we'll hopefully see better outcomes in the future. Thank you all very much. Thank you. Thank you very much.